We're back recording. Please continue.
Fantastic. Where there's a will, there's a way. All righty. So I'm not 100% certain where we ended. I know I was talking about risk management, and we have generally, I think we've covered this risk management part. Because did I get to the point where I was saying that these policies and procedures should attract, right, great stuff. So then we're basically at the next part anyway, the first half of the webinar, which is some types of liability insurance. And the ones that I think are very important, or should be able to look at by the RPM members, are the ones that I've got on the screen. And I mentioned two liability claims examples, the tennis court and the all-terrain vehicle rollover. So you can bear that in mind as we progress. So the first one is personal legal liability. And basically, I think the first thing I just want to say, against the backdrop of those two claims I've just mentioned, that the public liability section of the Farm Pack product doesn't give you any protection for your personal legal liability. It's excluded in the Farm Pack liability section, and most people would be aghast when they hear that. So, yeah, a farmer wears two hats on his farm. So if you're taking your kids to the local school in the morning, those activities are being conducted in your personal and private capacity, wearing your personal hat. But when you're doing farm work, with say your dairy cows and the local vet is doing AI or something, and that interaction with the vet and the work you're doing is you're wearing your farming business hat. So there's one person, two hats, two different exposures, two different liabilities, and they're insured in two different places. Private liability or personal legal liability appears in the home and contents section. And that home and contents section, I highly recommend that you take out both covers. Even if you only have a kettle in the house to insure it, take out both covers. Why do I say that? So another little claim example. So, if you or your wife goes to town on a rainy Saturday morning to buy food for the home for the next 2 weeks, and whilst walking across the pedestrian path, perhaps with your mind on something else, your umbrella pokes the eye out of a young child crossing the pedestrian crossing, then you have zero cover for that, unless you took out contents cover for that kettle, and you've got $20 million cover. It's hugely important. The younger the person is who suffers an injury that has a long work career ahead and studying and all that, the bigger the compensation. So, like, say, for example, a swimming pool accident on the farm, that would be covered if you insure the building, because a pool and an outbuilding is included in the definition of a building. So if accident arises out of the ownership or occupancy of a building, then the legal liability will cover that part as well. But if you only insure your house and not the contents, you may not have any cover if your house dog bites someone at the front door. So these little bits and pieces are hugely important. Obviously, every liability claim in particular is complex in terms of the facts. But the point is that the liability cover is insured differently. One for the liability arising out of the ownership or occupation of the home building, and a different one for the liability arising in circumstances other than the ownership of a building. So that's fairly broad and extends to cover away from the home, and could include cover for worldwide travel, not only Australia, but when you're traveling in the USA and you poke the eye out of someone on a pedestrian crossing. These little bits of information are hugely important, and it all turns on if you take out contents cover. So as is a pool or tennis court, for example, is part of the of an outbuilding or will be covered, but the tennis net may not be. That's contents, right? So it depends how the injury occurs. So employer's liability is obviously very important. Workers' compensation is mandatory, and note that your employees are excluded in the public liability section. Another insurance policy I think that is worthwhile looking at is professional liability, because at the margin between public liability and professional liability, there's a bit of a grey area. Sometimes there's a bit of interplay there, and the difference matters if you're actually caught. I'll talk more about that, the public liability policy and PI a bit later. Again, public liability excludes liability of personal capacity, and that can become quite testy when a farmer or the operator of the business is not incorporated. As I said, you wear two hats on the farm, once in your personal private capacity and others in your business capacity. And the cover you get, the activities that you were doing at the time that an injury occurred matters a lot. Product liability is obviously usually important for the IPA members, and I'll talk about that. There's also a really interesting discussion that could be had about unregistered motor vehicles, either on a manufacturing plant on an estate, industrial estate, like a forklift. They're on farms and in those estates. Where would that cover vest? Or do you have cover? I've had claims that, and it's a hugely consequential event on a farm. So I want to chat about, as promised, public liability and product liability a bit more. The analysis that you see on the screen, or as I'm going to speak about, is really just a standard form of policy, to the extent that exists, because the public liability wording can be modified by extensions, inclusion extensions, and special conditions. That having been said, I think a really important thing to remember is that liability insurance is there to protect, as contrasted with professional indemnity, is there to protect the insured from certain types of wrongs. Like in English law, it's called a tort, and hence the term tortious liability, which sounds like a tortoise, but it's very succinct because it means a wrong in the eyes of the law, something that you do, injury you cause to another person or property damage, is what's covered in public liability is a tort, and that's an actionable wrong, an action meaning legal action. So something that you've done and someone that can sue you for that falls within the ambit of public liability. So what is public liability as contrasted with professional indemnity on the right-hand side? It is claims made against you by others. I've highlighted the word others. Under PI, you'll see it's claims made against you by a client. I don't intend to contrast in the same way going through, but just to highlight that point. Claims are made against you by others, and others means the public, right? It's public liability. But that can include people that you do business with. It's anyone out there other than a professional client. And it's for personal injury and death or property damage caused by the insured's business, not for you in your personal capacity, out of your farming business. So a tip on some of the exclusions. Each section of a farm package product contains exclusions for all other covers, the covers that occur elsewhere in another section. So if you're cherry picking covers in a package policy, it needs to be done by someone with experience in the product, because if you think you've got public liability cover or personal legal liability cover, and you don't take out the home section, you don't have that cover because it's excluded in the public liability section. And all the way through the policy, the same pattern occurs. So the next point I'd like to go to is product liability, which is very important. Claims made against you by others, you'll notice that this is very similar to product liability, basically structured the same way. It's for personal injury or death for property damage caused, in this instance, by a product. And then the next sentence says, with which you have dealt with in various ways, and then in the conduct of your business. If you've had any involvement with a product, you have liability after it has left your premises. So if you have been involved with the manufacturing or the construction, the alteration, if product is repaired or serviced or treated or sold or supplied or distributed by you, you basically may be brought into an action for product liability. But what does product liability actually cover, or what does it not cover? So it doesn't cover a claim from a purchaser of your product in circumstances where that claim arises because the product, merely because it doesn't function in the way that it should, the required quality, or fails to perform to its intended function. All it does, it will cover the costs if that failure results in physical injury or property loss. That's what's covered, not an economic loss. Economic loss or financial loss means you have lost money because you've been out of action, or your businesses hasn't been able to write. That's financial loss. All public product liability does is will pay for the costs of injury or property loss that occurs out of the sale of those property. It's the physical injury or the actual property damage, the cost of repair or the cost of medical help, not the resulting loss. And with that, I will go to professional indemnity on the right-hand side. And you'll notice that, as I stated, it's for claims against you made by a client. And there's a reason why I think, until I get to know some of the businesses better in the RPA, if there's interest, I think there may be reason for some members to take out professional indemnity insurance in the manufacture of certain products aimed for dogs or something with a certain formulation. You might have consultants that tell you what's required or check it, but you're still on the hook ultimately. They'll sue you as the supplier. You might have a counterclaim against professionals that guided you, but I think it is arguably of relevance to members. So it covers professional negligence or errors made in the work that you've completed for your client. I said pursuant to an agreement. It's inherent that you've got to have some kind of agreement, and preferably a written agreement. That's the key. Spelling out what it is that you're going to give them advice for, regardless of whether the fee is paid. And that comes out of left field, that comment, whilst acting in the performance of your professional occupation. So there are two buckets to this. The classic professions, engineers, lawyers, and accountants, where professional standards legislation applies. Generally, the professional associations control that whole place tightly, like controlling, the issuance of a public practice certificate, like as a chartered accountant. If you withhold a public practice certificate, you can't practice. Medical practitioners not getting a practice license, so on. So those associations act in concert with legislators. They set up insurance schemes for professional indemnity, and they have the ability to negotiate, because they negotiate en masse. They set up schemes and they get limits for the profession. So if you deal with a lawyer, you'll see there it's got a member of the Professional Standards Association, and their liability is capped. They do that. They work with the government to get these. They work hand in glove, basically, to set that. It suits both parties. And then the other bucket is the non-professionals. Now, this is really interesting in relation to the IPA. So you need not be one of those the traditional professionals. There is another category called occupational professional indemnity, which the law looks at. That's financial advisors, insurance brokers. Like if you've got an Australian financial services license, you've got that because the corporations law says you must have it. But that's not the traditional professionals. And to take it further, in the second category of occupational professionals, it's basically anyone who has an occupation that either does work of a skilled nature or according to a recognized discipline with an accepted system of work, or is engaged to provide specialist advice upon which your client is entitled to place reliance. So it's clear that, you know, plumbers and electricians and all that are starting to fall into these categories now. It's to give you an example, I received a call for a bricklayer wanting professional indemnity. It's like it's utter chaos and madness in Australia in litigation space, and the insurance professional group working group, I think it was, it said that per capita Australia is now more litigious than anywhere in the world, more litigious than the state of New York per capita, which is unbelievable. So just a little bit of insight. In general, for liability insurance, the insured must prove the circumstances and the amount of the third-party loss that's being claimed, its liability to the third party and the terms of the insurance contract, and that the insurance contract actually responds to its liability to the third party. So there are very special circumstances in which you will have legal liability. That's why it's important to note the term legal liability as opposed to straight liability.